Good afternoon. It is September 15th. We're here for a Planning, Housing, and Parks Committee work session. We have two items on our agenda, the first of which is Zoning Text Amendment 2507, Retail Sales and Service, Cannabis Dispensary. We have the planning staff and Ms. Nadeau here with us. We have our colleagues on the Planning, Housing, and Parks Committee, and we have with us Councilmember Albanaz, who is here on this particular item. A public hearing was held on the 17th, and we are going to go through this item now. I'll open it up to see if Councilmember Albanaz has any opening comments on this. Then I'll open up to colleagues if they have any remarks, and then we'll turn it over to Ms. Nadeau to walk us through the packet, and then turn it over to planning staff as needed. And planning staff also has some specific information that the committee and some committee members have requested that we'll get through as we go through the packet that they'll be prepared to share. So with that, let me turn it over to you, Councilmember Albanaz.
Thank you. Thank you to Mr. Chair and the members of the committee for indulging me with crashing your party this afternoon. So just for a little bit of background and context, this issue was first brought to my attention by the town of Kensington. And of course, I am a Kensington resident. And it was brought to my attention specifically with regards to a cannabis dispensary that was being proposed very close to downtown Kensington. And while obviously the law has been enacted, I learned a lot about the law through this process. And I really, once again, want to thank Ms. Nadeau for being such an outstanding communicator and translator, and her ability to work through some sometimes pretty complex legislation. But you will hear from her in a moment, but the short of the long is that the state did, I think, our colleagues in Annapolis did a good job of trying to provide reasonable boundaries and allowed a runway for each jurisdiction to be able to transition to what is a pretty significant change overall in terms of our state. And while this obviously is a very highly regulated industry, there are currently provisions that prevent cannabis dispensaries to be placed within 500 feet of what are deemed sensitive areas. That include schools, child care centers, and other similar facilities. But they also included a provision that allowed local jurisdictions to enact their own zoning ordinances to, in addition to the 500 feet, prevent cannabis dispensaries from being placed within 100 feet of residential homes. And that has occurred in the situation here in Kensington. It's important to note that that situation would not be impacted by this legislation because this legislation is proactive, not retroactive. But the concerns raised by residents will be raised by other residents if we don't enact something like this, or at least have a conversation about it. These facilities are slated to stay open 7 days a week until 9 p.m. And as we have seen from other cannabis dispensaries that have been very successful both in the county and our region, they are very popular and very well attended. And so while we want to ensure that we are providing reasonable platform for business owners to be able to carry out their businesses, we also need to take reasonable measures to protect our residents as well. So that is the spirit of the bill, and I look forward to the ongoing conversation. I also want to thank our planning staff, the members of the executive branch, and the county and council attorney who worked collaboratively on this bill as well.
Thank you for that. Any comments from colleagues? Seeing none, let me turn it over to you, Ms. Nadeau. Thanks for all your work, and I will ask you to walk us through the packet.
Okay. So first, starting with the public hearing, it was on June 17th. Several speakers testified. The council also received some written testimony. First, testimony had asked for clarification on how this would impact restaurants. I noted in the packet here that it will not. It only affects the dispensaries and then residences. There is testimony in support expressing concerns about dispensaries abutting these residential properties. That testimony addressed safety concerns, construction noise, and late hours. There was also testimony in opposition, though, noting that alcoholic beverage retailers are allowed near residences and are arguably a more harmful use, but not subject to the same restrictions. And opposition also noted negative impacts on local businesses. So going through the impact statements, first, the RESJ impact statement found a minimal impact. The RESJ statement anticipated burns and benefits of the 100-foot setback, depending on whether you're talking about the residence or the dispensary. They noted that while new dispensary owners may be burdened, households near those dispensaries could benefit, so the effects would likely offset. The climate assessment from the planning department found no significant climate-related impacts and did not recommend any amendments related to the climate assessment. And then there was a planning board recommendation. It was 4-1, supporting the ZTA with amendments. The amendment was about how the language is drafted, which we will get to later in the staff report. But planning also had suggested that the language might be too restrictive, given that most of the zones that permit retail are mixed-use zones. So this could be close to a prohibition in these downtown areas. To explain what those mixed-use zones are, that means our commercial residential zones that have both businesses and residences, many of which are downtown. And I think at this point is the information that the committee had requested or that certain council members had requested from planning. So I will turn it over to Mr. Berbert.
Thank you for that introduction. I am Ben Berbert, representing the Montgomery County Planning Board today. We definitely looked at some analysis here on where the cannabis dispensaries could be located based on current zoning. And as Ms. Nadeau pointed out, that's our commercial residential zones, CRN, CRT, and CR, as well as the employment zones, which is EOF, LSC, the NR, and GR, and then the industrial zones of IL and IM. With the exception of IL and IM, all of those other zones allow some amount of residential development in them. And I think that was really our concern, is that not necessarily on day one would this create a prohibition, but over time, if everything we envision comes true and we get more and more mixed use, you're quickly going to start eating away at available locations. What we did look at more in depth are a couple of things. One, we did a countywide mapping exercise. It's way too detailed to sort of print out in a snapshot and show you, like, here's what this is. You kind of need to zoom in on it. So we did create a web map. That web map, if it's not publicly available, will be imminently, and hopefully there's more time for council members, both on PHP and full council, to kind of digest that and ask planning questions if you have any at your own time. But basically what we did in that web map is we basically said, where are the areas that allow dispensaries and that are not likely to be impacted by a 100-foot residential buffer, and that's basically the industrial zones. Then we mapped everywhere that allows dispensaries. Currently, the full parcel fell without the buffer, but could become in one day if there was residential mixed-use development occurring. We mapped all the parcels that had at least a partial overlap with a residential buffer, but wasn't a complete overlap. And that's really where the grayest area of all of this is, because we're actually measuring the building to the 100-foot buffer. And we just unfortunately have not had enough time yet to look at every building on every one of these overlap parcels to get into the deeper detail of whether they're allowed or not. And also, we'll note buildings can move, and so it's a little difficult. It would be a snapshot in time and not necessarily looking at the future. And then we also mapped where is the whole parcel covered by that 100-foot buffer because it's mixed use or because it's completely surrounded by residential. And that's what's been mapped there. We took that same methodology and we sort of applied it to the 18 existing dispensaries in the county. 16 are actually in the county controlled by our zoning. The other 2 are in the city of Rockville and are not controlled by our zoning. And we found that 5 of them would become non-conforming adoption of the ZTA. They are completely within sort of the buffer area now. There was another 8 that are on parcels that are at least partially overlapped by the buffer. We did check, because it's just 18, that those buildings are not within the buffer, and so those are on buffered property but would actually still be allowed. And then there were 6 more that are in zoning that could allow residential growth but do not have any buffer overlapping them. And there was only 1 that is on industrial property that we found that under any scenario that would continue to most likely not become non-conforming. And so really the hard part is what the planning board is trying to represent in its comments are maybe not on day one will there be a sort of an immediate prohibition. There is still land out there, and it about splits the same way this did. There's maybe 30% of the areas where you can do cannabis dispensaries now would become not allowed because of the buffers. And then you have about another 70% where it's just the unknown. And as we continue with our mixed-use development and our residential mixed-use areas, you will one by one start losing properties to this. And so it wasn't something that we felt so strongly about that we had like a given fix, but it was something we wanted to flag as part of the discussion that this is something that could start happening over time. And we just wanted to make sure the council was fully aware of that, in its decision making.
Okay. Any questions specifically about that? Councilmember Girondo.
Thank you. I appreciate the analysis. I know I had seen, and I guess it'll become available, like a map showing what you just described that is pretty. There's a lot of space where this either wouldn't be allowed or potentially couldn't be allowed in the future, depending on what we would want to happen. More housing being built in zones where it's allowed to be built. Did you look into, and I also saw something related to the awardee breakdown of who has licenses for these. Obviously there's a racial equity component here too, that I don't think OLO, in saying that they couldn't make a determination, they cite that they didn't have the racial breakdown of awardees. So I'm assuming they didn't have the information that I've seen, which showed that, 54, almost 55% of the awardees are African American. Obviously, Councilmember Mink and I introduced a bill that the council passed unanimously, which also was state authority that created some financial relationship to communities that have been impacted by the failed war on drugs, particularly related to cannabis, and reinvestment that comes from funding from these facilities that goes back into those communities. My understanding is that there's like there could be a potential financial impact in that regard as well. Well, let me first ask, I guess Ms. Nadeau would be did OLO have the information that's now available when they made their analysis? Do you know?
I am not sure if OLO had that information when they issued their statement.
Well, we're going to make sure that's available to the public, right? Those documents.
Yeah, I can make sure, depending how committee goes today, if this goes to council, I can make sure that information is included, or I could do an addendum either way.
Yeah, the concern that I have, and I understand why it was introduced, is just with seeing those maps and then hearing the analysis from planning, I don't, and the connection to the revenue for communities that have been impacted by when cannabis was illegal. I have a lot of concerns about rushing in and making a prohibition now on top of, even though the state gave us some authority, without digging deeper into some of these maps and what some of the consequences could be. So, that's my concern, just having looked at it coming into today. Did the planning board have any discussion about that at all?
The board did note its concern that this will quickly start limiting where options are available. My recollection of that meeting, they were even almost more concerned about how this could affect existing businesses, right. Particularly if they become non-conforming in their ability to expand, if they're doing well and want to take over the neighboring, storefront in a shopping center or part of a mixed-use building from where they are. And again, there wasn't a lot of consensus on what the solution is. I think the board just wanted to, make aware that we were concerned. That's something where I think Montgomery County is a little unique. I've worked in other jurisdictions in the state, and a lot of them still have traditional commercial-only zoning, business-only zoning. We're unique in that we're trying to make more mixed-use development, and so almost all of our zones could be residential. That's not the case in a lot of the jurisdictions in Maryland. But I don't know how we necessarily separate out which mixed-use zone is more rightful of being protected by a buffer versus others. And again, I think that's where the board ultimately couldn't come up with a clear policy direction on what the recommendation is. We just wanted to flag that we thought there could be a problem as this sort of built out in time.
What would be so you talked about the non-conforming. You got the 30% that are currently in it. So the bucket that would be non-conforming. You mentioned one potential downside to that. If you wanted to expand, you wouldn't be able to because you're not conforming. What else comes with that? Just for the... Is that the main
Yeah,
restriction?
that's the main thing that happens with non-conforming uses, is they're allowed to continue existing. You're not automatically prohibiting them, but they can't expand or enlarge. So if they bought a new space or wanted to expand the size of the room, they wouldn't be able to do that with DPS.
And you kind of create this potential race against time. Like if you wanted to expand, say the same one wanted to put one in a different location, but that might be covered under this, you couldn't do that. Okay. And I guess just the last question for now. I'm sensitive to like the desire of the sponsor to try to address community concerns, and I wonder if there's not a way to do that without taking this approach. So that's what I would just throw out there. But we've turned it
Happy to turn it back to the sponsor.
Yeah, so, as this has evolved, and as like in every legislative process, new information becomes available. And, when I saw that map, I was like, whoa. But at the same time, and so, commercial spaces with high-rise apartments where people buy into properties that have that infrastructure, expect more of a nighttime of economy, and more of a diverse set of businesses is not what I had in mind when I introduced the legislation. It's the strip mall that is right next to residential homes that are not equipped or appropriate to have a facility of this kind of use next to their properties. The building where the dispensary is going in Kensington was a bank, and so it had bank hours. It was not open in the evening. It was barely open on the weekends. And there are a lot of young families who live immediately adjacent to where this property would be. And again, as it's important to note, existing licensees would not be impacted by this unless they want to expand on their current site. But I'll just note two things. When our colleagues in Annapolis disputed this, they put pretty significant restrictions on how many licenses can be sent, because they did not want to repeat the mistakes of other jurisdictions that did not have as many restrictions, where you saw one almost on every corner. And so we in Montgomery County control our liquor locations. And as a matter of practice, it's not a policy, but as a matter of practice, they try not to place them close to people's residential homes. And there are some similarities in crossover with cannabis as a business. So I would be open to, that was a long-winded way of saying I would be open to, having another bite at the apple and seeing if there were some reasonable compromise that didn't impact those downtown commercial office spaces, but allowed some reprieve for other communities where there are more residential homes.
Let's turn it over to Councilmember Fana Gonzalez, and then I'll have a couple questions too.
I would say that the list of concerns that I have were beautifully presented by Council Vice President Yowondo, and I appreciate very much the response by Councilmember Albornoz. I feel like I need more information and more time, so I can just put it out there. I do, to make sure that we're making a sound decision that is going to be responsible, not just for today, but for the future. The other thing that I would like to highlight, because it wasn't mentioned, is these are highly secured locations. These dispensaries are like, it's not like you just walk in and that's it. No, this is the type of facility that we want, so we don't have people selling drugs on the streets. This is actually positive. And I want to make sure that that's not lost in the conversation. I live between two dispensaries. I live in Wheaton. I have one in downtown Wheaton and one in Glenmont. My house is literally between them. I have no problem. Because the people who are going in, they know what they're doing, and they feel safe going into these facilities, and that's a great thing. So let's not lose that perspective. Again, if we can hold this, that'll be great.
Okay. First of all, I don't think we're ready to vote today. It seems pretty clear, so just want to be clear about that. It was unclear when we went into this of whether we would be ready. I will say I think the language of the legislation is very straightforward. Normally, we need more time to come up with, additional language and, compromise on language and so forth. I don't think that's the case here. I think it's a question of impact and intent, and how do we thread the needle, it seems. And it's clear that there's some questions and concerns based on the intent, not only of the sponsor of Councilmember Albernaz here and of the community, but also of the state, and the impact of what it would actually mean materially. So a couple things. One, we have not received anything from the state on this, have we?
Correct. We have not received anything from the state.
So it would be helpful for us, and perhaps we could send a letter from the committee asking the state delegation to weigh in on what the intent would be in terms of balancing what they were hoping to accomplish versus what we're allowed to do. We want to make sure that we're taking the enabling legislation and not creating a conflict between the state. I know there's been some conversations. I've had some individual conversations, but I think having something that demonstrates that would be helpful for us. I think it would also be helpful. We don't have liquor store standards, as Councilmember Albernaz says. We have practices because we are the liquor store business in Montgomery County. There's a wide range of views on that. Whether we should be or shouldn't be, but we don't place requirements or restrictions on that because we are both the business and the regulator when it comes to liquor store, which is different than other jurisdictions. But it would be helpful to know what are the regional standards for liquor stores in our neighboring jurisdictions. What are those standards that are being used? If we're not going to use our own standards because we don't have any standards, what would be a reasonable standard if we looked at that when we come back? I think that would be helpful. And then I would like, as one way to address this, to at least think about, and as I was listening to Councilmember Albernaz talk about maybe there is a way to thread the needle and what the community interests are, and some conversations that I've had previously, and hearing loud and clear the concerns that colleagues have. Could we look at a map that exempts CR and CRT from the legislation? So CRN and some NR, some of the other zones where we have retail that tend to be more community serving retail and less commercial, as Councilmember Albernaz was talking about that distinction. I would be interested in seeing, I think it'd be helpful for the committee to see how that would actually work if we did that, and what impact that would have, and whether or not that could help us thread the needle. Because perhaps there is maybe it isn't the distance number, maybe it is the type of retail and the type of commercial environment that we're talking about, because we have different types of standards in those for the similar reasons, actually, of how close they are to neighborhoods and to communities, and that's why we do zoning to a certain extent. And if there is another better alternative to that, if planning or our legislative attorney and our team says, we understand what you were asking for, but here's another option to look at, I would say add that on too, as kind of a third option. But I just was hearing colleagues, and it came to mind that perhaps we could differentiate to nuance this a little bit more in terms of what type of zones we're talking about. So okay, Council Vice President Joanna.
Yep, thank you. I appreciate those suggestions. I think that would be good to see as we try to look at a different, maybe a more tailored approach. I really appreciated Councilmember Fanny Gonzalez's point that these exist because it's a step forward. It's an effort to remove the lack of safety and street distribution of drugs, and particularly in this case marijuana, and they are highly secured. And as you talk about the type of facilities, I think the closest one to me is it's in a strip mall type thing, but it's in a strip mall that's not next to houses.
Right.
Yeah. And so I think I'd be interested to see this map, because there might be a way to limit current impact, but also thinking about the future too. You don't want to forestall potential there's no space for it to grow or to to be. So I think that would be helpful. I just wanted to, if I could, with the chair's indulgence, just ask Mr. Stoddard something related to these in general. Yeah. You came, you're all dressed up. Just if there, as the one who kind of is overseeing this as ACAO, is there anything that you would have to share? Are there public safety concerns? Does the executive branch have a view on this?
Yeah, we talked to first off, Earl Stoddard, Assistant Chief Administrative Officer, and I'm joined by Mr. Hartman behind me because he oversees the DPS portfolio, so we work on this issue collaboratively. I want to recognize that first. We did talk to the executive this morning, and based on the analysis the planning board raised, actually we reacted very similarly to the way that the committee did, which is we understood the concerns and certainly heard the concerns of the residents that were provided and thought them reasonable, but at the same time, when we saw the planning board analysis, we too were concerned with the long-term prohibitions this could provide, and so we came to express that from the standpoint of sort of the conversation you already had. So we were actually texting saying this is exactly the conversation we were hoping to have, and so I think the broader I don't think there's any broader concerns beyond those that you've raised, which is the notion of having a drive-through operation right next to a house is a very different conversation from a mixed use in a high rise, for example. And so there probably is a more nuanced solution that the executive branch thinks would be appropriate in this case. And we think that the direction that the council conversation and the sponsor are having right now are exactly where I think the executive branch would be as well.
I appreciate that. Thank you, Mr. Chair.
Okay, let me turn it back to the sponsor here, just to get your sense of kind of the general direction that we're heading with the follow-up information that we have. Any other suggestions, perhaps, that you have, and I want to turn it over to you.
Yeah, thank you. Just to repeat and kind of state the obvious. So first of all, I need to give a big shout out to Kristen Tribble in my office, who's been point person on this and has done a fabulous job. So as the sponsor of the bill, we commit to going back to working with Ms. Nadeau based on the feedback shared by the committee, sharing a draft with you all before a follow-up session to give you time to process, absorb it, see if you have any questions, thoughts, concerns. And assuming there can be some reasonable consensus, Mr. Chair, I would humbly request that we come back to see if we can vote on something that we all agree on. And if we do, then have the committee make a recommendation to full council. There are a lot of residents who are following this conversation very closely and knowing that we're at least continuing deliberation, thoughtful deliberation, which we are, of course, would be helpful. But that would be my suggestion, Mr. Chair.
Absolutely. That's my goal. That's why I was trying to have very tangible things for us to look at, to receive, and to get back for consideration. Ultimately, come back to the committee, but I think really making sure that the sponsor and his office, Ms. Tribble, and others are looped into that, as well as the executive branch for any feedback from DPS, from public safety or otherwise, I think would be helpful. And having our legislative attorney and having planning work through those scenarios with feedback, I think would be helpful. So my intention is for us to try to thread the needle here. I think we hear some of the concerns. There is a balance from the community perspective, which I'm very sympathetic towards and have heard quite a bit from, with also the reasonable standards for businesses, particularly new emerging businesses that we're trying to help and support in other ways, and not putting ourselves in a position where we're saying you can open, but you can't expand. You can open, but you can't change, in a rapidly evolving and changing dynamic. So finding a way to thread that needle and to find the nuance that I think would be helpful to balance those concerns will be important. And I am hopeful that we can get there, and certainly expect that we can. And, we also want to make sure that we're being partners on the implementation of this with our state colleagues, since, ultimately they have delegated this authority to us. They had a certain intention of what they were hoping and thought we would do with it. I think this map probably surprises them too, I would imagine, but it would be helpful to have a full, clear understanding of that as well. So I think we've got a plan for moving forward, and we're going to move the ball forward. I think today was helpful to flesh some of that out, and I think we can come back once we're ready with a proposal before us to try to find the right balance. Great. Thank you. Appreciate it. We are going to dispose of this item then until we're prepared to come back with thanks for Councilmember Albernaz for joining us and for putting this forward, and for all the community members who have weighed in on this, since there was quite a bit of interest on it. We appreciate it. With that, we are going to move on to our next item on the agenda, which is zoning text amendment 2509. Funeral and interment services, alkaline hydrolysis. I will readily admit and thank my colleague on this committee for introducing me to the concept of alkaline hydrolysis, which I had never heard of and was not aware of, and have quite an education that I have now learned about, which has been fascinating and interesting, and appreciate her moving forward with this. With that, let me turn it over to her to make any introductory remarks, and then I'll turn it over to Ms. Nadeau to walk us through the packet. Fortunately, this one I think is pretty straightforward. Interesting topic, but a fairly straightforward legislative proposal before us to make sure that we're creating as many options and as many environmentally sustainable options as possible.
Thank you so much. I'm so happy that you enjoy the whole topic. We're all gonna die, so it's like we had to talk about it and see how the process is gonna be before you leave the decision to your family. That's why it's so important to have a will, and this is part of the conversation. I'm gonna let staff to go through the report, but there is one thing that I wanted to highlight is the potential amendment that I'm completely on board with. Thank you to the staff for highlighting the. We don't want to mess with our pet cremation, so this is a way to fix that. With that, I'll turn it back to the chair. Thank you.
Yeah, appreciate that as well. I think there'll be broad support on that amendment. Makes a lot of sense. Why not expand this to pets and animals as well? If it's good enough for people, it should be good enough for our furry family members. So with that, let me turn it over to Ms. Nadeau to walk us through this, and we can take that up at the appropriate time.
Okay, so as you can guess, there was a public hearing and all the testimony was in support, noting that it's a more environmentally friendly option. We also received a letter from the Funeral Consumers Alliance of Maryland and Environs, noting that it's also cost effective. Planning board supported approval of the ZTA as introduced, so had no amendments for me, which was very exciting.
Yeah. We won't ask and test on the process of alkaline hydrolysis.
We also reviewed, planning board also reviewed a climate assessment and found slight positive impacts on addressing greenhouse gas emissions and sequestration. The idea being that alkaline hydrolysis is a greener process than cremation normally, and also reduces land consumption concerns. We did receive an RESJ impact statement that noted that OLO cannot anticipate the impact of the ZTA. They noted a long history of racial inequity in the funeral business generally, but did not have the data to anticipate the impact of this ZTA in terms of business owners in the county. Okay, so in May 2024, the General Assembly passed the Green Death Care Options Act, which established the requirements and the prohibitions for water cremation facilities. I guess I'll pause here to say it's called alkaline hydrolysis is the official name. It's also called water cremation. It is also called aquamation. As part of that work that the state did, they are going to be drafting regulations. The Office of Cemetery Oversight and the State Board of Morticians are going to be working on those. As of the date of the staff report, and I did check again this morning, those regulations are not yet out. And those will just basically outline the specific requirements, because all of this licensing is going to be done by the state. So while DPS will approve these applications for the UNOs and any internal building work, the state is actually the one managing and licensing the process. Okay, so what is alkaline hydrolysis? So the way that it works is the deceased body is placed in a pressurized vessel that has water and an alkaline solution until it decomposes. This is an alternative to cremation that requires fire and burning of fossil fuels. There is a picture on page 3 of the staff report for you. The process takes 3 to 12 hours, depending on the model of the equipment, and then, of course, the size of the body as well. The resulting chemicals, because it's a very frequent question, is what happens then. The resulting chemicals are broken down, they're treated, and they become a completely sterile, DNA-free solution that just goes down the drain. Who regulates that process? WSSC. And as noted earlier, licensing is done through the state, but any internal building permits, such as plumbing and electrical, could go through DPS. And then lastly, what happens to the bones? The bones go in a machine called a cremulator, and that's where you get what's usually referred to as the ashes, which is actually similar to traditional cremation. It's the same process. So the family still receives their loved one's remains. So the ZTA allows this by making 3 changes. First, defining alkaline hydrolysis, and then also defining crematory. The reason to define both was, one, so that we all know what alkaline hydrolysis is, and then while crematory itself was a use, cremation was not defined. So there's now a definition for both, so you can see those differences, and the ZTA just uses the state definitions. Second, the ZTA allows alkaline hydrolysis as part of the definition for a crematory. So now if you had a crematory use, you could do either the traditional burning or the alkaline hydrolysis. And then lastly, the ZTA makes alkaline hydrolysis an accessory use for a funeral home or undertaker. So a funeral home in the current zoning ordinance is a facility that holds and transports remains to and from premises, embalms, allows visits, conducts business, and conducts funeral memorial services. So by letting this be an accessory use, you're not going to have facilities where this is all they do, but if you are a funeral home and want to add this, you can do that. As you saw from the image below, it doesn't take a ton of space, so they would just reserve that separate room to do this process. And an accessory use, of course, is incidental and subordinate to the principal use of the lot. And so to note here, it shouldn't increase the neighborhood impacts for the funeral home because you're not going to get any more visitors than you would have had for funeral services. And that is the ZTA overall, except for the potential amendment. I pause in case there's any questions.
Thank you for that extremely detailed analysis of it, probably more details than many people were prepared for in this particular setting, but we really appreciate it. Clearly, you have done your work in learning about these items and issues, which we very much appreciate. So thank you for that. Let me turn it to Vice President Joanna.
Thank you. Yes, and appreciate all the work that's been done on this and the introduction. The Office of Cemetery Oversight and the State Board of Morticians and Funeral Directors, right? Okay, they're the ones working on the regulations.
Yes, they are.
My only question was around that, because you have kind of like 3 actors. You got the DPS side of it, which this will allow us to, using the state authority, allow this to happen. Mm-hmm. You got the state regulatory bodies, which have yet to issue their guidance, right? But regardless of what we do, any facility would be bound by the state regs, right? And so my only question was one of like the chicken egg thing, the timing of it. Would there be anything in the regs that would impact what we were doing here in the zoning that we might have to come back? And that was one kind of general question. Not knowing what the regs are, I don't know if you can answer that question, but do we have any insight based on, because this is, I'm assuming there's nothing, and no one in Maryland is doing this yet because there's no regs, right? Or Baltimore's doing it.
Baltimore, I believe county or city has one. Baltimore County
They have one. Okay, yes. And so presumably.
But they will be bound by the regs as well.
Okay, so that would be my only question is like if the regs changed, would it change what we had to do? I'm okay if the state body is going to do it. We're obviously not going to get into the details of what's the proper way to do this type of cremation. It was just more of a timing thing. And then similar question with WSSC, right? Like the one concern, if I had seen one in other places, was like, well, what do you do with the people being freaked out about how the remnants are disposed of? And I'm assuming WSSC has a process for that and is on board with that. So those are my kind of 2 questions of the timing given the state regs and then like what was WSSC's process, just knowing a little more about that. So I'm fine generally. I think it sounds great. I want people to have options, and but those would be just things that maybe between now and the time that if we could inquire with the state body and inquire with WSSC about just something to include, to me, it seems like a box just to check on the path to saying we want to allow this right now prior to state regs coming out, if that would be allowed, which it sounds like it would be because Baltimore County is already doing it.
Yeah, no, those are totally fair questions. So the intent when it was drafted was to keep it very narrow. So all the ZTA does is say, yes, crematories can do this. Yes, funeral homes can do it. So all the other like process and licensing rules won't conflict with the state regs. But I can definitely reach out to the board and send them the draft and double, triple check that they don't see any issues. But also keep an eye out for when those regulations come out in case there is something in there that conflicts. But the intent was to draft the ZTA narrowly
And just
enough that
allow
we can
generally,
go ahead and start.
From a DPS perspective, which is our role in the process.
Yes, exactly, because there are people who've been interested and approached.
I think what would be helpful, I mean, even just for an informational purpose. So from my read of it, I think it's an important point, but from my read of it, this is no different than us saying hospitals are allowed from a land use perspective, and here's, and saying, there's a new thing that happens in a hospital that we hadn't contemplated, and saying that's allowed on a hospital site too. And then it's up to the state that regulates hospitals actually to determine the standards with which actual hospitals and the operation of a hospital can occur. It's also up to WSSC, which is really regulated more by the state than by us, to figure out what are water safety standards? When the hospital disposes of medical waste, for instance, how does that get treated in the wastewater, et cetera? I see it very similar to that in the sense of kind of what our role is. Our role is the land use role. That's what we're taking up here. I don't see a conflict or a concern there, but I think it would be helpful for consumers as well as for the operators. The operators are probably more well-versed on the timing of the regs than consumers would be, to include our understanding of the timing by the state board so that we know what that looks like and have an update operation. That's at least my understanding, and I think it would be helpful. So either way, even though I don't think it's an issue, I think reaching out to them to get that information, not just the yes or no, but actually the information that we can post with our information in the packet for full council, ideally to say, based on what we hear from the board, here's what we understand their process is for the operational regs, even though that's not our role in this process. With that, let me turn it over to my eager colleague and the sponsor of the zoning text amendment.
The good thing is that your eager colleague has done her homework.
Yes.
And yes, Leva was correct. The decision that we're making today is related to land use, to allow it, but anything that goes inside, that's the state, and those regulations are going to be out anytime now. Could be as early as next week, so very, very soon. If they're posted by the time, they're not going to give us the draft, by the way, we ask. But as soon as that they're out, we can definitely include them, but there's not going to be an issue. I feel very confident. If you want a triple check, go ahead.
Yeah, I don't think there's an issue at all. That's what I was trying to note. But I think that's helpful, the additional information that you have provided, that you found. And I think if it's ready before full council takes this up, that would be ideal, that we could just post to it. And if it's not, at least a general time frame, even if they don't provide the draft, but a general time frame of when we can expect it to be available in public, just so that information is there altogether, I think would be helpful.
I totally agree. I just know I've been in this job long enough. I know my residents, and I know the questions that will come. So I think to the extent that we can post, but yeah, that sounds great. Thank you. I appreciate my colleague.
Yeah, agreed. The information would be helpful there, although I don't think there's a conflict. Okay, we have an amendment proposed. Essentially, this changes humans and human bodies and human remains and decedents to just remains and decedents, making it more broad, and making it more broad allows animals to be included in that. So when pets are going through this same process and families are making these decisions, they will have this option available to them as well. What's good for people should be good for pets as well. And so you heard support for that and nod. So without objection, we will vote to support that amendment that is included in the packet. And are there any other items before us? let me turn it back to the sponsor, Councilmember Fani Gonzalez.
Just very quickly, perhaps you can even emphasize this when it comes to full cancel. On the WSSC issue, they do have to provide a permit for discharge of the water. So that also takes place. So maybe you can put it on the report so people know. But that, yeah, they need approval too for that. So.
Appreciate that. Unfortunately, many of us have gone through this with family members. It's the most impossible position for families to be in, to have to make these choices. There are so few options. There are so many difficult decisions. There is a lot happening. And unfortunately, this is an industry that is in many ways controlled by a very small number of companies, which make prices very, very high and options very, very limited. So anything we can do, even on the margins, to provide more choices to families, to provide more information to families who are going through their most difficult moments and the most impossible choices they have to make, I think is a good thing. So I really appreciate your work on this. Councilmember Fani Gonzalez, really appreciate the work of staff and planning and Department of Permitting Services and working through this, and colleagues on this committee. Anything that we can do to help, I think, is a step in the right direction. The fact that this not only provides an additional choice, but one that is a more environmentally sustainable option, even if it's not one that all people choose in cremation, it's a choice that should be available to those who do want it, and the breadth of choices should be available as well. With that, I think we have taken up this item. We have a zoning text amendment before us. All those in favor of the zoning text amendment as amended, please indicate by raising your hand. That's 3-0. And we will send this along with a unanimous committee recommendation to the full council. With that, those are all the items that we have before us today, and this committee is now adjourned.